Climate Law Matters, 2025 Caselaw Roundup. Hello, listener, and welcome back to our podcast, Climate Law Matters, in which we explore the legal developments across different sectors to address the key issue of climate change. I am Grodzinski, a barrister at 39 Essex Chambers, and today I'm very excited to welcome Anna Tranter, a solicitor at Irwin Mitchell specialising in environmental and planning law. Hi Anna, it's great to have you with us.
Hello, thanks for having me.
This is a special end-of-year episode. We're going to be giving you a roundup of the most significant UK climate law cases of the year. So it's a slightly different format than some of our other episodes, and we hope that our listeners find it useful. So this has been a busy year for climate litigation, both at the international and domestic level. At an international level, we've had, obviously, the ICJ advisory opinion as a key development, and I would refer our listeners to the fabulous podcast episode that Flora Curtis has recorded on the ICJ advisory opinion. And in terms of domestic climate change policy, the Carbon Budget and Growth Delivery Plan was published in October 2025, following two successful judicial reviews brought of the previous carbon budget delivery plans in 2022 and 2023. This podcast, however, is going to focus on the case law that has emerged this year. There have been some major legal milestones in the past few years, which have had trickle-down effects that we've seen this year. The first of those that we're going to look at are costs implications in climate law and environmental law cases. Anna, there have been some major developments in this realm in costs this year. Could you give us an overview of what has happened?
Yes, of course. As you said, we've had a couple of cases handed down this year where the court has grappled with the applicability and the scope of the Aarhus Convention and its cost protection provisions. And that's following the hand down of the global feedback judgment in 2023. A very quick reminder, I'm sure your listeners are aware, but the global feedback judgment essentially narrowed the applicability of Aarhus claims to those where the relevant national law is designed to regulate or protect the environment, and not where those grounds of challenge just broadly relate to the environment at a higher level.
Thank you. The first case that I think we want to talk about is the Badger Trust case.
Yes, so this was an application made by Badger Trust and Wild Justice against Natural England, and it was a procedural hearing within a wider JR proceedings against Natural England's decision to grant a number of badger culling licences. Natural England had applied to raise the standard Aarhus cost cap from the standard £10,000 available for organisations up to £20,000 for Badger Trust and up to £30,000 for Wild Justice. That application was dismissed, with Mr Justice Fordham considering the two-limbed test for what constitutes proceedings being prohibitively expensive of real-world affordability and the objective reasonableness standard. In assessing objective reasonableness, the court must consider the need for environmental NGOs to retain the viability to be repeat players in environmental litigation, i.e. Mr Justice Fordham indicated that environmental NGOs need to have the financial ability to take on this case without draining their resources and prevent them from taking on further legal cases in the future, essentially saying that effective access to justice for an environmental NGO means repeat engagement. In this case, it was found that the increased cost caps would not be objectively reasonable on the basis that this claim was a classic environmental case without financial interests, and all arrangements for legal representation that had been put in place were reasonable. It was found that Natural England had spent too long focusing on the details of the claimant's finances, so this real-world affordability limb, and not enough time considering what the reasonable level of the cap would have been in the circumstances. And in that way, the objectively reasonable requirement can act as a freestanding protection, even where those costs might be considered to be real-world affordable for the organisation in question. So some key takeaways from that decision. The court is essentially entitled to consider the default cost caps as a soft presumption, and any challenge to those caps must be clearly justified by the applicant and have strong reasons in support. Even if varying the cost caps could meet the real-world affordability threshold, it must also be shown that lifting that cap must be objectively reasonable, which in this case was not met. For environmental NGOs or other groups considering applying for Aarhus cost protection, this case serves as a reminder to not narrowly focus on the affordability and quantum side of that argument, but to consider more broadly how the wider reasonableness standard can be used.
Thanks so much, Anna. Those are some really useful takeaways with really good practical implications. I think the next case that you wanted to mention for us was the Green Lane Association case.
Yes, so this is the case brought by Green Lane Association Limited against Central Bedfordshire Council. This was an application by the defendant council for a declaration that the claimant's statutory review of a decision to grant a traffic regulation order was not an Aarhus claim, or in the alternative, that the standard costs cap should be varied. In this case, the council tried to rely on global feedback to say that the relevant sections of the Road Traffic Act did not regulate environmental quality, set environmental standards, or create environmental obligations. And therefore, the purpose of the legislation was not to regulate the environment, and therefore Aarhus cost protection should not be allowed. On the other hand, the claimant argued that each of the considerations set out in Section 1 of the Road Traffic Act, all related to the environment, alongside the requirement for the local authority to have regard to the effects of a potential order on local amenities and national air quality strategy. I won't run through each of those requirements here, but they are set out in Section 1 of the Road Traffic Act 1984. In this case, Mr. Justice Ridge read the definition of environmental information in the Aarhus Convention alongside those requirements set out under Section 1 of the Road Traffic Act and was satisfied that wording was consistent with the protection and regulation of the environment. So some key takeaways from this case is that traffic regulation cases, for now, appear to remain within the scope of Aarhus following the global feedback judgment. And it appears to be a fairly wide reading of the requirement for provisions of national law relating to the environment. Separately, there was a procedural point raised in this case around timing to apply for Aarhus protection. The judgment clarified that the Aarhus position should be set out by parties as early as possible, and a defendant who doesn't lodge objections within the acknowledgement of service is unlikely to amend this at a later date without good reason.
Thank you so much for that, Anna. I believe that relatedly, and I know we said we were going to focus on case law, but it's probably worth mentioning, relatedly, the UK has also had a recent disagreement with the Aarhus Convention Compliance Committee. Do you want to say a few words on that?
Yes, so this is a fairly recent development following the Aarhus Convention's Compliance Committee's findings that the UK had failed to ensure proper public participation on environmental concerns when it was drafting its post-Brexit legislation, and as well that the UK lacks a consistent system for consulting citizens on new laws with significant environmental implications. The UK government has responded by saying that it strongly disagrees with these findings, but has also indicated that it intends to continue to work within the framework. So that sets, I think, a broader context for these Aarhus-related claims that we've seen come down this year.
So watch this space, listener. This is a controversy that may keep developing.
Well, absolutely. The other major area of development that I think we wanted to talk about, Ella, is the impact of Finch, the judgment handed down last year. I wondered if you would like to talk about that.
Yes. So to remind listeners, who I'm sure are well aware, the Supreme Court decision in Finch on behalf of the Weald Action Group and Surrey County Council was a groundbreaking case in 2024, in which the Supreme Court held that downstream greenhouse gas emissions, otherwise known as Scope 3 emissions, were, quote, direct and significant effects of an oil extraction project within the EIA regulations, and therefore an EIA, an environmental impact assessment, must assess the downstream effects on climate change from the combustion of the oil produced. So that was the 2024 case. And then this year, we've seen cases examining that authority. The first of those was a decision in January of this year, so right at the start of the year, Greenpeace and Uplift, who challenged the Advocate General for Scotland, who represented the Secretary of State for Energy, Security and Net Zero, and his predecessor, the Secretary of State for Business, Energy and Industrial Strategy. This case concerned two offshore oil and gas projects, which have been granted consent under the Offshore Oil and Gas Exploration, Production, Unloading and Storage EIA Regulations 2020. The parties actually agreed in this case that, following Finch, the decisions to grant consent were unlawful where they did not take account of downstream emissions. The issue that the court was considering here was what was the appropriate remedy. The court held that the appropriate remedy here was for the decision to be reduced, which is the Scottish equivalent of a decision being quashed in England, such that it could be taken again, this time accounting for downstream emissions. However, the reduction or quashing was suspended to allow the developers time to arrange how they're going to proceed before the reconsideration. And this case is particularly interesting because it provides sort of an indicative roadmap for how these cases where decisions are now unlawful following Finch will be treated. So that was January of this year. And then in May, we had the decision in Boswell. So this was a judicial review brought by Boswell against the Secretary of State for Energy Security and Net Zero. It went to the Court of Appeal. The decision was May of this year. Rose Grogan from 39 Essex actually represented the first respondent. And this case was a judicial review of the grant of development consent for a new gas-fired electricity generating station with carbon capture infrastructure. The High Court refused the claim for judicial review, and in May, the Court of Appeal dismissed the appeal, holding that the Secretary of State had been entitled to conclude that the development's benefits outweighed the significant adverse effect of its greenhouse gas emissions, and had been entitled to draw upon National Policy Statement EN1 in doing so. I'm not going to go through all the grounds in this case, but the significance that we wanted to highlight was the limits that this case illustrates on the impact of the Finch Authority. In this case, the greenhouse gas emissions had been properly assessed within the EIA, and the adverse impacts of those greenhouse gas emissions had been taken into account in the ultimate planning balance. The key paragraphs of the judgment in this case, with respect to Finch at least, are paragraphs 93 to 97. And I'm going to read out just a small fraction of that for our listeners. So paragraph 94 of the judgment says as follows: the appropriate scope of an EIA is one thing. The judgment reached on the significance of particular environmental effects, such as greenhouse gas emissions, is another. The judge, that's the High Court judge, said that the present case was analytically quite different from Finch, and the dicta of Lord Leggett in Finch do not impact on the alleged error of law here. And the Court of Appeal said, we ultimately agree with that conclusion. The decision in Finch has no resonance for the issues in this case. And they continued in paragraph 95, as we understand the law in its present state, it can still safely be said that the question of whether emissions are significant for the purposes of the EIA legislation is a matter of judgment for the decision maker. And they cited Finch at paragraph 58. So although Finch is, of course, having significant impacts, this case of Boswell does illustrate the limits of that impact.
Brilliant. Thanks for that, Ella. It's really interesting to see how the impacts and scope of Finch are being refined and applied in latter cases. And I'm sure we haven't seen the end of the post-Finch case law. In fact, I'm not sure we've even seen the end of post-Finch case law for this podcast episode, as we're going to move on to our aviation section, where we're going to consider a few aviation-related cases heard this year. And I wondered if you wanted to give us the headlines on the recent Luton Airport judgment, which I believe also considered the impact of Finch.
Yes. So this is a judicial review on the application of Luton and District Association for the Control of Aircraft Noise against the Secretary of State for Transport. The judgment was handed down on the 8th of December, and all 5 grounds were rejected. So far as I'm aware, the campaigners who brought this judicial review are considering appealing it to the Court of Appeal. So watch this space. There were 5 grounds, as I've mentioned. The interesting one in relation to Finch is ground 1. The key distinction to bear in mind with ground 1 is the distinction between inbound and outbound flights. So those are flights coming into the UK and going out of the UK, and how the carbon emissions from those flights are considered. In ground 1, the argument was that failure to include greenhouse gas emissions from inbound flights in the EIA was contrary to Finch. The key context here is that UK carbon budgets include the carbon of outbound flights, but do not include the carbon of inbound flights. The High Court rejected ground 1 of the judicial review and said that it was lawful for the Secretary of State to conclude that inbound flight emissions were not capable of meaningful assessment against the UK carbon budgets, given that the UK carbon budgets do not consider inbound flights. And therefore, the carbon of those inbound flights did not need to be assessed. That's paragraph 72. And in any event, the court found that the Secretary of State had concluded that the inbound flight emissions were not significant and therefore didn't need to be assessed in any event. That's paragraphs 75 to 78. There were 4 other grounds, and as I said, this case may or may not be appealed to the Court of Appeal. I believe the next aviation case that we wanted to mention, Anna, was the Jet Zero case.
Yes, so these are challenges brought by Possible, the 1010 Foundation, and Galba, the Group for Action on Leeds Bradford Airport, against the Secretary of State for Transport. Galba was represented by Steph David and Celia Reynolds from 39 Essex, and indeed from this podcast. By way of background, the UK government's Jet Zero strategy was launched in 2022 and outlines how the aviation sector can achieve net zero emissions by 2050. It includes measures like sustainable aviation fuels, aircraft efficiency improvements, carbon capture technologies, and carbon markets and consumer awareness initiatives. The challenge alleged that the strategy was legally flawed due to a number of factors. One of those factors was excessive reliance on speculative and unproven tech, offsetting and sustainable aviation fuels, which have yet to be scaled, without taking sufficient action to manage demand. Demand management measures had been ruled out of the strategy before it had been subject to a public consultation, which was contrary to the advice received from the Climate Change Committee, which emphasised the importance of management of demand and encouraging controls on passenger growth. So in light of that, the challengers alleged that there had been a failure to provide a robust public consultation of the strategy. The court dismissed all grounds and upheld the lawfulness of the strategy in consultation. The court found that the government had been entitled to adopt a tech-led approach to aviation decarbonisation, and as well that they had been within their rights to exclude demand management measures from policy options. The exclusion of demand management measures, even if it had been advised against, didn't render the consultation unlawful, and that there had been no legal duty to undertake a further inquiry into demand management once ministers had taken a clear policy stance. There was also a challenge relating to the public sector equality duty, which was also dismissed. The decision went to the Court of Appeal, which heard the applicant's application for permission to appeal just 3 days ago at the time of recording, on the 12th of December 2025, and the court refused permission to appeal to the Court of Appeal. So I think some key takeaways from this case is that as the law stands, there's quite a high bar for challenging sectoral decarbonisation strategies, with a need to show a substantive legal flaw beyond a policy disagreement. Public consultations don't need to show every option, just those that the government have actively been considering. And in that way, there is some judicial deference to government climate strategies being shown by the courts, I think.
Thanks, Anna. That's a really interesting summary. That brings us to the end of the substantive section of our whistle-stop tour of the recent case law. But before we round things off, shall we give our listeners some headlines of developments to look out for and any judgments being handed down in 2026?
Yes, absolutely. So kicking things off, looking at corporate accountability at the international level, a claim against Shell has recently been filed by the survivors of Typhoon Odette in the Philippines. The claim alleges that the company's emissions have materially contributed to global warming and increasing the likelihood and severity of the typhoon, causing deaths, personal injury, and property destruction.
That'll be a really interesting one to watch out for. Looping back to the issue of costs, specifically the applicability of the Aarhus Convention, Foodrise, formerly Global Feedback, have been granted permission to appeal to the Supreme Court to challenge the 2024 judgment on the applicability and scope of the Aarhus Convention and subsequent available costs protection.
Yes, I think the Foodrise case is definitely one to watch. And who knows, you might find yourself here in a year's time giving a whole new update on the case costs law that might come from that.
Maybe we'll do a special episode when that one comes out.
On the theme of aviation, a challenge brought by campaign group CAGNY over approval of plans to bring a second runway into use at Gatwick Airport is due to be heard over 4 days in the High Court. And the dates for that hearing are January the 20th until the 24th.
And finally, the Dieselgate scandal continues. The hearing in that matter has been ongoing since 13th of October this year, and closing submissions are now expected to be heard in March 2026. So have a look out for the judgment, which is expected in summer of 2026, and quantum will be assessed in the autumn, so that is still ongoing. That brings us to a close. So thank you so much, listeners who've made it to the end of this podcast. We hope that this has been an informative roundup of the things that have occurred in 2025. And we hope we've given you a little taste of what is to come in 2026. Thanks for listening this whole year of podcasts. Everyone have a lovely holiday period and Happy New Year. We'll see you in the new year.